only thing we have to fear is
in war,
fear itself.
there is no substitute for victory.
Let us never negotiate out of fear.
We stand undivided, forever united, fighting hand in hand for the liberty we've earned, for glory and honor, for our sons and daughters, ever mindful of the lessons we've learned. Let the torch of freedom burn.
Thomas Jefferson said, "The Constitution of most of our states and of the United States assert that all power is inherent in the people, that they may exercise it by themselves, that it is their right and duty to be at all times armed, that they are entitled to freedom of person, freedom of religion, freedom of property, and freedom of press."
Inherent in the people, that's you, that's me, that's David. We've got to exercise those rights, and that's why Foundations of Freedom Thursday happens here on WallBuilders Live. I'm Rick Green here with David Barton. Thank you for joining us at the intersection of faith and politics. And this, more than any other day of the week, we get a chance to take your questions and gives you a chance to direct the program a little bit and pick the topics that we're going to cover on today's program. You can send your questions in to radio@wallbuilders.com. David, we got some good questions today. The first one's on a topic you've actually got a great CD and also a book on, judicial activism. This one comes from Joe. He said, "I'm concerned about judicial activism. I understand what you're saying about Congress having rules of self-defense, but how exactly would that work? Suppose the Congress decided to fight the court's decision in support of gay marriage. What would they do, meaning Congress, what would they do to bring the court back in line? Can you give us an example? Thanks for all you do, Joe." All right, David, so judicial activism, we talk a lot about it on the program. Give us an example of how Congress actually pushes back.
Best way to do that is to go to the actual word in the Constitution and read it. Now, as the Constitution is written, Article 3, which is the part about the judiciary, which is the smallest clause of the three branches of the Constitution, this is what it says, and everybody pay attention here, focus. This is old English wording, so it's going to be more than 4 words to a sentence. It's going to be fairly long with a lot of commas. But
well, you can't use any words with more than 3 letters.
I don't know. These dumb founding fathers we had who didn't even have internet, I don't know what they were doing, but somehow they managed to use a lot of words with it's like reading the King James Version of the Bible. Okay, so that's what this is about to be. But let me read Article 3, Section 2 of the Constitution. It says, "The judicial power shall extend to all cases and law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority." So judicial power, that's what it covers, is law and equity under the Constitution, treaties, and federal laws. It says it extends also to all cases affecting ambassadors or other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversy between 2 or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between the state or citizens thereof and foreign state citizens or subjects. So pretty simple. Here's what the judicial power can extend to: federal laws and controversies between 2 states or 3 states or 4 states, or between citizens across state lines, where that you can't, if Texas has got a fight with Oklahoma, you can't go into Texas courts or Oklahoma courts. You have to go into federal courts. You don't want a home court on that. You want a neutral court. So the federal courts get to handle controversies between citizens in different states, or if I'm in Texas and claim land over in Arkansas, that's going to go to a federal court. It's going to be a neutral arbiter of this. So that's what it affects you. Now, the 11th Amendment of the Constitution, the 11th Amendment came along and added a change. It says, "The judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or citizens or subjects of any foreign state." So that's the one part it did remove out. But then to go back and finish with Article 3 of Section 2 of the Constitution, it says, "In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions under such regulations as Congress shall make." So bottom line is, all right, if it's a case affecting ambassadors, we have the Amistad case where that Spain sued the United States. if it affects public ministers and councils. We've got a diplomat from Afghanistan or a diplomat from Pakistan or whatever, and those in which a state shall be party, as when Texas sues the EPA. The United States Supreme Court has original jurisdiction. Those cases go right to that court. They don't have to go through any lower court. They go right to the Supreme Court. In all the other cases before mentioned, which deals with federal laws and controversies between states and deals with anything else, it says the Supreme Court shall have appellate jurisdiction. In other words, you go through the district court, the Court of Appeals, onto the Supreme Court. Both is law and fact, but listen to this, with such exceptions and under such regulations as the Congress shall make. So let's say...
Now that didn't say as the Supreme Court shall make.
No, as Congress shall make. So let's say that Congress passes a law, and there's a law that goes through Congress, and Congress passes a law that said, with all of our federal parks, with all of our federal timberlands, with all of our federal forests, we don't want any of that undergrowth in the forest burned. None of it will be burned. This is a federal law that you cannot burn, and private industry burns under trees all the time. They don't have forest fires because they keep the fuel off the ground. Federal government has forest fires like crazy they can't put out because they won't burn the fuel that's lying around the ground, all the dead branches that fall and all the dead trees that fall over, etc. So that's why you have the damage to Yellowstone and damage to so many national parks, Yosemite, etc. But that's the law Congress passed. Except when they passed the law, the majority leader of the Senate was Tom Daschle, and he put in an exception according to this clause of the Constitution. He said, except South Dakota, my state, no federal court is allowed to review any of this law in South Dakota because we're going to cut the underbrush in South Dakota. We don't want to lose our forest, so we're cutting the underbrush. Guess what? Immediately, the federal courts are not allowed to take up an issue. If somebody from South Dakota sues and said, that's not fair, we think that they should not cut the underbrush in the forest of South Dakota, it'll get thrown right out of court because Congress has made an exception and said the court cannot hear that issue. Congress has done that 200 times. It's called the exceptions clause. So, Joe's question on marriage, all Congress has to do is say, we are exempting the marriage issue from any federal court. No federal court is allowed to touch that. It belongs to the states. It does not belong to the federal government. And we're passing a federal law that says no federal court can pick this up. That's the exceptions clause. That's a simple way to do it. Another simple way to do it is right now when the court makes a decision, the court cannot enforce a decision. It takes the Justice Department to enforce the decision. Congress simply passes a law that says not one penny of federal monies can be used to enforce this decision of the U.S. Supreme Court. So there's not a federal marshal, there's not a federal prosecutor, there's not anybody at the Justice Department that can spend 1 second of time enforcing the Supreme Court decision because no federal money can be used to enforce it. It becomes a moot decision, much the way that the Dred Scott decision became a moot decision. It's still on the books, or was still on the books till they passed the constitutional amendment, but nobody enforced it. And that it has the same type of mootness that the Dred Scott decision had. So that's another way that they can do it. Another thing that they can do is the Constitution allows that the only court the Constitution creates is the Supreme Court. All other, what the Constitution calls inferior courts, are created by Congress. And all Congress has to do is pass the law and say, we saw the Northern District of Georgia struck down the marriage law. We're abolishing the Northern District of Georgia court. It doesn't exist anymore. That's a creation of Congress. It's not a creation of the Constitution. We're just wiping the court out, and they can do that. And so those are easy ways of self-defense that have historically been used to limit the courts. They can still be used today because they all have their basis in the Constitution. They've all been proven throughout history, and there's precedent there for all of those.
And David, the Supreme Court has acknowledged that. I mean, they've had cases where people tried to bring some of those issues, and they said, hey, we can't do that. There was a positive exception made. The Constitution clearly gives the legislature that power, and we can only, their words, we can only examine its power under the Constitution. They can't. So it's there. It's worked in the past. We just got to get Congress to be willing to do it. Got to take a quick break. We'll be back with your questions when we return, right here on WallBuilders Live.
Thomas Jefferson said, "In questions of power, then let no more be heard of confidence in man, but bind him down for mischief by the chains of the Constitution."
This is David Barton with another moment from America's history. What is the purpose of government? Founding Father Oliver Ellsworth believed he knew. Oliver Ellsworth was a delegate at the convention which formed the Constitution, and later he became the Chief Justice of the U.S. Supreme Court. Concerning the purpose of government, Oliver Ellsworth declared, "The primary objects of government are the peace, order, and prosperity of society." Yet how were these goals to be achieved? Ellsworth explained, "To the promotion of these objects, good morals are essential. Institutions for the promotion of good morals are therefore objects of legislative provision and support, and among these, religious institutions are eminently useful and important." Founding Father Oliver Ellsworth believed government could never reach its goals apart from the help of religious institutions.
For more information on God's hand in American history, contact WallBuilders at 1-800-8-REBUILD.
Let the torch of freedom burn.
Abraham Lincoln said, "We the people are the rightful masters of both Congress and the courts, not to overthrow the Constitution, but to overthrow the men who pervert the Constitution."
Welcome back. Thanks for staying with us here on WallBuilders Live. It's Foundations of Freedom Thursday, and we're talking about a question that was asked about judicial activism and how the Congress can push back against judicial activism. And David, you were talking about the exceptions clause there in Article 3. I mentioned as we were going to break that the court has acknowledged that clause is not only there, but that it works. Just if I could read real quick from their case. This was a case where somebody had brought an issue that Congress had exempted out and said the court can't address this. And the court said, we're not at liberty to inquire into the motives of the legislature. We can only examine its power under the Constitution. And the power to make exceptions to the appellate jurisdiction of this court is given by express words, those words you just read a few minutes ago. Without jurisdiction, the court cannot proceed at all in any case. It's quite clear. So, David, the court knows that power is there. Why can't we get Congress to use this power more often?
Well, there's a couple of reasons. The first reason is they all graduated from our government education system where we don't study the Constitution anymore. One of the things we've talked about in numerous programs and several of the congressmen have talked about is they're not familiar with the Constitution. I mean, they just don't know. As a matter of fact, I was at a conference recently where I was speaking on judicial myths, 5 judicial myths, and I just quoted from the Founding Fathers and from the Constitution and quoting from the Founders' own writings. And the congressman said, we've never heard that. And so they've asked me to come to D.C. and do a training for them on ways to limit judicial activism and all the training I have to do is I just simply show them the original documents. I mean, one of the congressmen asked about this a few years ago, and he said, how do I learn this? I said, what you need to do is simply get the Judiciary Act of 1801, 1802, get the debates, because that's right after you had the nation elected an anti-federalist Congress and House and Senate and a president, Thomas Jefferson. And then the Federalists in a lame duck session said, well, we're going to create a whole bunch of new federal courts and we're going to stuff them with federal judges, and then the anti-federalists will be stuck with it. Well, when the anti-federalists came in as the new Congress, they immediately repealed all those new courts. They just wiped them out. And so the discussion in that 1801, 1802 period of how they could do that, why they could do that, what power Congress had over the courts is extremely revealing, because the guys who are sitting in there doing it are the John Adams, Thomas Jefferson type of guys. They're the guys
this wasn't 200 years later, the founders all dead. These were the founders.
These were the guys who had done it. And so, and he read that book and still has that book. He got actually an 1802 copy of that book and read it, and it just changed his whole view. And so that's what it takes, because we no longer deal with this. I would just about bet you ask any government teacher in the United States right now, what is the exceptions clause? And I would bet you that 999 out of 1,000 cannot tell you. Now, they're the ones that are teaching the kids that are going to be our citizens, and those citizens, many of them will grow up to be our elected officials. But if the teachers don't know it, how do the students get it? And so that's the biggest problem we have, is we don't cover this in government schools at all. There's a little more covered in private schools, and if you get to somewhere like Liberty University, you'll actually get the Constitution taught to you. Hillsdale probably teaches this. I haven't seen what they do on exceptions clause, but it's real clear stuff. So that's the answer. But number one, that means we have to educate ourselves first off. And
right.
Once we do that, Then we can educate our elected officials, which is what happened in that conference where I spoke recently. And then once that happens, they can start pushing back on a congressional level.
Very quick break here on WallBuilders Live. If you want to find out more about these things we've been talking about, David's got a great CD on those 5 judicial myths, as well as a book on judicial restraint, how to make that happen, and then our extended course on Constitutional Live will take you through these cases we've been talking about in that history. Stay with us. We'll be right back on WallBuilders Live.
President Thomas Jefferson said, "I know no safe depository of the ultimate powers of the society, but the people themselves. And if we think them not enlightened enough to exercise their control with a wholesome discretion, the remedy is not to take it from them, but to inform their discretion by education. This is the true corrective of abuses of constitutional power."
This is David Barton with another moment from America's history. In the minds of many today, government is a purely secular institution and is not in any way to be joined to religious principles. The result is that too often our public policies are now enacted without any consideration of their spiritual consequences. However, the Founding Fathers believed that even a political act should always be examined from a spiritual viewpoint. For example, in his inaugural address, President George Washington declared, "We ought to be persuaded that the favorable smiles of heaven can never be expected on a nation that disregards the eternal rules of order and right which heaven itself has ordained." President George Washington believed that the blessings of heaven would reside on this nation only so long as its national policies embraced godly standards.
For more information on God's hand in American history, contact WallBuilders at 1-800-8-REBUILD.
Let the torch of freedom burn.
President Calvin Coolidge said, "The more I study the Constitution, the more I realize that no other document devised by the hand of man has brought so much progress and happiness to humanity. To live under the American Constitution is the greatest political privilege that was ever accorded to the human race."
Without a doubt, we are blessed to have such a great Constitution here in America, but we need to know it. We need to know what those foundations are, and that's what Foundations of Freedom Thursday are all about here on WallBuilders Live. And by the way, if you're enjoying today and getting into some of these subjects, we do this almost every week, and we've got a lot of archived Thursday programs on our website at wallbuilderslive.com. Just click on the archive section, and you can go back to those. Next question comes from Wayne in Indiana. He says, "I was listening to an archived, speaking of archives, archived WallBuilders Live program about the First Amendment. David was talking about lawsuits under the Establishment Clause that are awarded costs. So this is like attorney's fees and even some other expenses. How did this come about, and what was the reasoning? Why the discrepancy with lawsuits under the Exercise Clause?" So, David, give us a reminder first of the difference in those two clauses and how we came about this, because this is sort of like the exceptions. Congress has certain powers, and Congress set this up in terms of where you can get which clause you can get attorney's fees for.
Yeah, what it amounts to is if you sue to take out a religious activity today, the government will pay you for doing that. So in the case going back a few years ago to the Ten Commandments that was taken out of the Alabama Capitol, Judge Roy Moore, the ACLU got paid $437,000, as I recall, by government entities for having sued and taken that out. I think the case up in Minnesota a couple of years ago where they took down the historic picture of Jesus that had been there for I don't know how many decades. I think they got paid $70,000 for taking that picture down. So for those on the secular side, this is like a judicial lottery, man. We just keep rolling the dice, filing suits. If we win, we get attorney's fees. We get paid for this. On the other side, if we file a suit and says, "Hey, teacher, you can't keep this kid from saying the word God," if we win, it doesn't happen. You don't get the same thing. So what had happened was you have fees awarded on Establishment Clause cases, but not on free exercise cases. But the reason it was that is you have to go back to 1947. In 1947, the Supreme Court completely reversed what establishment meant and what free exercise meant. See, establishment used to mean the government sets up a religious activity and forces you to participate in it and fines you and penalizes you if you don't. And if that was to happen, if the government was to say, "Hey, you got to attend First Baptist Church on Sunday morning or you'll pay a $50 fine," man, sue the government and you'll get paid for that. But it was to stop government abuse of power. But now the way it's done, since they've reversed that, they said, "Oh, if you allow that kid to say God at graduation, that's a government establishment of religion. No, it's not. That's a free exercise of religion. So with the new definition the court put out in 47, it really has reversed things now, so that you used to get paid if the government violated your rights. Now you get paid if you don't like what's happening within the government. And that's a whole different cause and effect, but that's really the situation. So you can go back in and change a few words in that statute and get that reversed, where that, for example, you don't pay on the establishment clause ones, you pay on the free exercise clause ones. And in that way, school boards and others are encouraged to allow free exercise, whereas right now, by paying on the establishment clause, they're discouraged from allowing free exercise, because if they allow somebody to say God, well, that's an establishment, and they're going to have to pay for that. So that's how you do it, is you just simply reverse that. But that's something that Congress can do if they knew about, but it hasn't been high on their list. John Hostetler used to do that. Then Dan Barton out of Indiana has been carrying that act, the Public Expression Religion Act, but it just hadn't had enough public notice for anybody to really clamor for it. And until it does, it probably won't pass.
Good one to write your congressman about as they begin their new session this year. Wayne, great question. Thanks for asking it. We're going to take a quick break. We'll be back in a moment here on WallBuilders Live.
George Washington. The Constitution approaches nearer to perfection than any other government hitherto instituted among men.
Hi, this is Tim Barton with WallBuilders, and I want to encourage all the pastors out there with the unique opportunity that we're presenting at WallBuilders. We're doing a special tour just for pastors that you can come and learn more about the spiritual heritage of our nation. Not just seeing the sites, but understanding the significance of what they are and what they represent. We get to go through the Capitol at night, and we get to see the spiritual heritage of our founding fathers, of who we are as a nation, where we came from. We bring in congressmen that'll tell you about current legislation, about our religious liberties and freedom, and what's going on in Washington, D.C. If you're a pastor, or if you want to recommend your pastor for this trip, you can go to our website, www.wallbuilders.com, and there's a link that's for scheduling. If you click on that link, there's a section for pastor's briefing. There's more information about the dates, when it's going, how it's going to happen. If you want to know more about our nation, our religious liberties, our freedom, our spiritual heritage, this is a trip you want to be a part of.
Let the torch of freedom
Thomas Jefferson said, "The constitutions of most of our states and of the United States assert that all power is inherent in the people, that they may exercise it by themselves, that is their right and duty, to be at all times armed, and that they are entitled to freedom of person, freedom of religion, freedom of property, and freedom of press."
Welcome back to WallBuilders Live, Foundations of Freedom Thursday. Our next question comes from Connie. She says, "Hey, David, first let me thank you for your faithful steadfastness to empower us to stand for righteousness and justice." Now to my question. Since the president appears to be willing to hurt Americans and deceive in order to keep his supporters, I'm starting to think the unexpected landslide was deliberate. Is it possible that Democrats voted for Republicans so they could have someone to blame before 2016? Of course, she's talking about the landslide in 2014, just a couple of months ago. Your Thursday show talked about the polls being wrong by 10 points for conservative Tea Party candidates. I hope I am not being a pessimist. I want to be wise as a serpent. I just think we need to be 2 to 10 steps ahead of the deceiver. Can you address what we can do to stay ahead of this? So David, concerned that is it possible that they wanted conservatives, or I should say Republicans? Conservatives didn't get a majority. Republicans did, but we got a lot more good conservatives in there. But did they want a Republican majority so that they could blame the problems that will come in the next few years on Republicans?
No, they didn't. That was not their intent. That would be like getting you and me to go campaign for President Obama. The worldview will not allow them to do that. Now, you might have had some middle-of-the-road Democrats, what we used to call Reagan Democrats, that may have voted for conservatives because they're just fed up with $18 trillion in debt or whatever. But on things like this, generally don't worry about conspiracies. I mean, there's a great Bible verse in Isaiah 8:11 that says, "Don't call conspiracy everything they do." Stuff like this, you just generally read it on its face for what it is. They just got whipped. And there's Republicans, they've had their times of being whipped as well. And by the way, one of the funniest articles I've seen in a long time, after this tail whipping that happened, you've got the New York Times And this is right at election time. They're calling for a cancellation of the midterms. Let's stop having these every 2-year elections. Democrats do well in the presidential year elections. They don't do well on the non-presidential year. So the New York Times is calling for us to cancel the non-presidential elections. Let's just make everything about the president every time. So, no, Democrats were not looking to do that, and they didn't help that. That's just not their worldview. You may have had some independent Democrats that did that, but again, it would be based on their worldview rather than on anything to create something in the future to blame Republicans. There'll never be a shortage of things to blame Republicans for, ever. No matter how good it's going, there will always be something there to blame them for. So take this one on its face. That's not what happened.
Yeah, I think it's going to be below freezing in my hometown tonight. Can I blame the Republicans for that?
That's it.
I mean, surely that's their fault somehow.
Yeah, that's right.
I mean, they caused global warming, right? And so
now it's stopped, and that's Republicans' fault too, because they had all this money invested, and now we wasted it all, and that's Republicans who did that.
Yeah,
somehow.
Makes perfect sense. There's so much logic there. Hey, folks, thanks for listening. Hope you enjoyed Foundations of Freedom Thursday here on WallBuilders Live. You can get more episodes of Foundations of Freedom Thursday on our website at wallbuilderslive.com.
Samuel Adams said, "The liberties of our country and the freedom of our civil constitution are worth defending against all hazards, and it is our duty to defend them against all attacks."
We stand undivided.